So there is a fundamental reform of India's criminal justice system which has taken place with the passing of these three new laws which replace the existing Indian Penal Code, Criminal Procedure Code and the Indian Evidence Act. Now at the root of this reform actually is the mindset which guided those laws and what needs to happen or should have happened but did not happen post-independence. Remember, these are British-era laws made with British sensibilities and a colonial mindset to preserve the colonial estate at the expense of the natives at that time, the Indian citizens. Post-independence, the reform should have happened and Indian sensibilities and care for the Indian life and Indian citizen at its core should have happened but did not happen. And that's what Union Home Minister Amit Shah has attempted and the Modi government has done. Now, what these criminal laws do, just an example to explain what this means in terms of mindset. In the British era laws, because the intention was to preserve the estate, colonial estate, any crime against the estate had precedence over a crime like a murder or a rape, which could be, beautifully seen in the sections. So, crime against estate, harming the state property, theft of state property was in the first half of the IPC in the sections 50 to 100, but the crimes like rape at 376, murder at 302 sort of gives you an idea of the mindset with which those laws were framed. Now, this has reversed. Crime against an individual, a citizen, takes precedence and that gets reflected in the numbers. So, the number one. Now, what happens is, times have changed so much, terrorism is a problem, the world is facing, India more so. So terror gets defined in this new triumvirate of laws and terror gets a specific punishment. So that's one thing. There was problem of finding ways to define terror under the existing penal laws that has been remedied. Come to rape, for example. Now there was no clear provision of giving a harsh punishment for a rape victim who was minor. In this case now, it becomes a strict death penalty and rape becomes a crime where anyone who does that has to face the hardest of measures that the criminal justice system can have. Also connected with rape, anyone committing rape of a major also gets a strict punishment of at least 20 years in prison. Earlier it was 7 years plus, depending on what the judge would come to based on whatever evidence the prosecution provided. So that's about that. Then terror defined. Then, given the fact kind of changes in technology that have taken place, these laws take those aspects into account. In fact, Home Minister specifically mentioned in his speech that not only technology as it exists today, these laws take into account technologies that would come over the next 100 years at least. So that's the kind of major forward-looking reform that these laws have brought in. Now, let's look at some other aspects. For example, mob lynching. There was this demand for about a decade or so more after the Modi government came to power that mob lynching was becoming a problem and that there were no specific provisions to deal with that. Now, mob lynching is a specific crime with a specific punishment for it. Similarly, there was this demand that sedition was a British-era concept and should have not been on the statute books. Many courts had, expressed their thought loudly that maybe sedition should not be on the statute books. So, given the basis of these reforms that they should replace the British-era colonial mindset, sedition also has been removed from the statutes. Sedition was essentially crime against the state that has been removed. Now, of course, there is crime against the country itself, against the nation, and that has been defined. So if you indulge in anti-national activity, that's a crime, but if you say anything against the state, if you commit something against the state, that's okay, because freedom of expression is there and that's sacrosanct. So that's a modernist reform that's come in, sedition taken away from the statute books. Also, if you look at it, there are some aspects of criminal jurisprudence which are forward-looking in terms of taking care of very modern human rights aspects. So earlier it was retributive justice. Now it is about reformative justice also. So the concept of community service for petty crimes has been brought in. Also, to make sure that citizens don't suffer and the criminal justice system itself does not become punishment. everything has been made time bound. So police has to file charge sheet in certain days. The courts have to take up the case in certain days, and the judges are supposed to dispose of cases in a time-bound manner. So that will take care of a lot of backlog of cases, 5 crore cases pending in the country. And these new reforms really tackle that head-on with a kind of time-bound manner that all the courts will have to deal, the police will have to deal with all the criminal cases that come to them. So these are the kind of reforms that have been brought in. Also, there would be a district prosecution board at a district level across the country, which will take care of bringing in technology, reforming, overseeing those changes, integrating these new laws with the overall criminal justice system and the prosecution system to make sure the transition dispute acts smooth and everyone is on board across the board at all levels of governance and the society.